Welcome to Young Legal Minds. I'm Dominic Simon, and this topic is on misrepresentation. Firstly, you need to understand what a representation is. A representation is a pre-contractual statement on fact that doesn't necessarily reflect the nature of any obligations within a contract. A representation, however, can become a term within a contract later on within the course of negotiations and then the contract being made. So, for example, before the contract's made, there may be a representation. In that contract, the representation, however, can harden into an obligation if it's inserted as a term into the contract. A misrepresentation would be a false statement of fact that induced the other party into the contract. So for a misrepresentation, there are three elements. Firstly, a false statement. Secondly, that false statement must be of fact. And last, that false statement of fact must be what induced the party to enter into the contract. It must be the reason why the other party entered into it. So, for example, if I'm entering into a contract with a businessman and I tell him he can earn £5,000 a week from this contract, that's likely to induce him into the contract. He's a businessman. That's a reasonable amount of money. That's going to persuade him to enter into the contract. If, however, that was a false statement, then that may amount to a misrepresentation, given that all factors are taken into account before the court arrives at that conclusion. The first thing you would need to do in a contract question, after just maybe giving a brief introduction on the law on misrepresentation, is distinguish between a term and a representation. This is very important because whether or not it is a term or a representation will determine the cause of action that the claimant can take. If it was a term, if the term was breached, because the term creates obligations, then that would be a breach of contract, and the claimant will be able to claim for damages for that breach. If there is a misrepresentation that is made, then the claimant can claim for a remedy under the Doctrine of Misrepresentation. The courts objectively assess the intention of the maker of the statement. So the question is, from an objective, because it's an objective test, the courts will be asking themselves, did this person intend for this statement to be a term or a representation? And they'll use the reasonable man test because it's an objective test, not a subjective test. In arriving at their decision as to whether or not the statement was a term or a representation, the courts take into account several factors. And just like offering acceptance, which has presumptions as to whether or not something was an offer or invitation to treat, there are also presumptions that relate to the law of misrepresentation. So, firstly, you need to ask yourself, has the statement been reduced to writing? If so, then it's likely to be a term, as shown in the case of Ella Strange, which suggests that if something's been reduced to writing, and especially if it has been signed for, then that reflects the nature of obligations. And this is basic contractual principles. I mean, a contract does not have to be in writing, but if some statements are reduced to writing, that likely reflects the nature of obligations and is thus likely to be a term. Furthermore, you need to ask yourself, does the party making the statement have specialist skill or knowledge? And I've put two cases up on the slide, Dick Bentley and Oscar Chess. In Dick Bentley, there was a car salesman who made the representation that a particular car had done around 20,000 miles. However, the car had actually done around 100,000 miles, and this was held to be a term. I'm not going to tell you why just yet. First, I'm going to contrast that with the case of Oscar Chess, and then I will explain why. There are actually three reasons why those two cases had different results, different conclusions, different reasonings. In the case of Dick Bentley, a car dealer represented that a particular car had done around 20,000 miles, as opposed to Oscar Chess, where just a man selling a car who had no profession relating to cars at all represented that a particular car was of a certain model. It was later found that it was not of that model. It was a different model. It was a completely different model to what had been represented. In Dick Bentley, however, the statement was a term, and in Oscar Chess, it was held to be a representation. The reason for this distinction was that in Dick Bentley, the car dealer had specialist skill and knowledge. He was a car dealer. Either he knew that it hadn't done around 20,000 miles, he would have known that it did around 100,000, or he could have easily checked to establish whether or not it was it had done 20,000 or 100,000 or whatever. And in Oscar Chess, the man who sold the car, who made the representation, had no specialist skill and knowledge, and so it was held to be just a representation. So this is how the courts approach such a matter. They're stricter with those who have specialist skill and knowledge. They're more likely to hold their statements as to be as to constitute a term. The next consideration the courts take into account is whether or not there was a lapse of time between the statement being made and the parties entering into a contract, and the time lapse that occurred. The greater the time lapse, the more likely it would be held to be a representation, because the greater the time lapse, the less likely that statement reflects the nature of any obligations. So if a statement was made in, let's say, May, and in July the parties enter into the contract, that's likely to be a statement. It's likely to be a representation, sorry. In the case of Routledge, a 7-day time lapse was sufficient enough to deem the statement as a representation, so time really is of the essence. So that is stage 1 of misrepresentation, of answering a misrepresentation question. So you will look at the relevant factors, you will look at the nature of the statement, you would apply the objective test, you would take into account the relevant guidelines, and then you would arrive at the conclusion as to whether or not it was a term or a representation. Be sure to check out stage 2, which I'll cover in the next video, but I will say that it is likely to be, stage 2 is likely to be split into 2 parts, so don't miss anything. But I wouldn't rely on this as your main source of information, because I'm not a lecturer. I am myself a law student. So I would, if you wish to, contrast this with your lecture notes and your seminar notes and notes from textbooks and other sources, but don't rely on this as your main source of information.